This is Colin O'Keefe with another episode of LXBN TV. My guest today says the Supreme Court's ruling in ERISA subrogation suit U.S. Airways v. McCutchen is short-sighted and will make personal injury lawsuits more difficult to settle. That guest is Stuart Carpey of Carpey Law and the Pennsylvania Injury Law Report. Stuart, let's start with the basics. Can you explain the case and the Supreme Court's ruling here?
Sure, Colin. Thanks for having me on board today. It was mid-April of this year, and the United States Supreme Court came down with this McCutchen ruling, and it had to do with a personal injury case where Mr. McCutchen's lawyer, I think, got him like a settlement of $110,000 or something like that on the personal injury case, and his employer was a sponsored employer health plan subject to ERISA, and the employer, U.S. Airways, paid something like $66,800 in medical benefits and wanted all of that back, which they had a right to do under their policy. There was a clause in the policy that said that they had a right to do that. It went up all the way through the appeals circuit. It went to the United States. It went to the Third Circuit, which ruled in favor of McCutchen on a more equitable distribution of the funds. And the United States Supreme Court, to the surprise of many of us who were in this area of the law, found in favor of U.S. Airways and decided that U.S. Airways had a right to recoup 100% of the amount that they paid out. So the short and long-term consequences of that decision are terrible. It was a terrible decision for personal injury victims. And even though the decision itself spoke to some of these consequences and maybe unforeseen consequences that these employers and employer-sponsored health plans might not have realized, for now, it is the law of the land, and it's not very helpful. And what I mean by that is these employers and these health plans do not hire counsel to proceed with these subrogation claims. They ride on the back of the personal injury claim. So a person who has a personal injury claim, bodily injuries, who now has to deal with a subrogation claim, their lawyer is essentially free legal help for an entity like U.S. Airways. U.S. Airways doesn't pay separate counsel fees, doesn't pay for the expenses of suit. So if U.S. Airways or an entity like that is getting 100% back of the money that they paid on behalf of the injured victim, they're getting a free ride. And typically what would happen at the end of the case, the plaintiff's attorney would be able to negotiate that subrogation lien down. So let's say in that case it was $66,800. The plaintiff's lawyer probably tried to have it cut in half or something to like $33,000. And U.S. Airways said, nope, we're not going to do it. So now if U.S. Airways or employers or employer-sponsored health plans are unwilling to negotiate their liens, it's going to be very difficult for plaintiffs. And more to the point, it's going to be more difficult for those health insurance carriers and employers to ultimately get their subrogation liens paid back. Somebody like me is going to have to look long and hard at the case to decide whether it's worth pursuing that case. So I think the decision is a little short-sighted, and I forget the justice who wrote the decision, but the justice actually spoke to that point, that U.S. Airways may have actually bitten off more than it could chew, because in the long run, they may have less cases that they can actually subrogate on.
I see. So in second, and I think you've explained this pretty well, but you wrote this case will make personal injury lawsuits more difficult to settle, so I assume that makes your job all the more difficult.
Yeah, I mean, every day we deal with subrogation claims for third-party entities like U.S. Airways. If those entities are unwilling to negotiate with us, less money goes into my client's pocket, and I dare say less money goes into my pocket. And in the long term, I know my my colleagues who do the type of work that I do are going to take, as I say, a long, hard look at the cases that we take, because if there's a large lien or if there's a potential large lien and not a very good chance of recovery or not enough coverage out there, if all the money's going back to somebody like U.S. Airways, why should I get involved in the case? So I don't think that the lawyers for U.S. Airways looked at that, but it is a consequence of decision in the case. It's a very, very unfair and it's not an equitable decision. Right now, it's something we're all dealing with.
I see. It's going to be interesting to watch play out. As you mentioned, the court may have bit off more than it can chew here, and this may have been short-sighted, so we're going to see some residual impacts in the near future. Once again, that was Stuart Carpey of Carpey Law. For more of his analysis on this case and for more on personal injury law, be sure to visit PennsylvaniaInjuryLawReport.com. And of course, you know where to go. Visit us at LXBN.com for hundreds of these LXBN TV video interviews, along with curated commentary from the Lex Blog Network's more than 8,000 members. Thanks for joining me today, Stuart.
Thank you, Colin.